All right. All right, so now that we're recording, I'll keep going. So like I said, this particular meeting is specifically, it's going to start as a workshop. This is an opportunity for the board members to ask questions about what their responsibilities are, any kind of protocols in terms of, how the meeting should run, how after the meeting, what needs to take place. No discussion about the particular appeals. So that's going to happen during the hearings. Once the workshop is over, when you guys are feeling comfortable that you've had all of your answers, and Natalie has been able to help you, we'll switch it to kind of a regular meeting, not meal, where you will have an opportunity to elect a chair and a vice chair. Once that happens, then you can close the meeting, and then that chair is going to need to connect with me. So we can set up a date for the other appeal that is sitting in front of us. So I'm going to, at this point, turn it over to Natalie Burns, who is our town attorney. And I'll let her lead the way. I'm going to mute myself. So unless you guys have any questions, I'm just kind of going to sit in the background, looking at any attendees or panelists that I need to promote.
Thanks, Vika. Can everyone hear me okay?
Yes.
The beauty of Zoom. So thank you for attending tonight. As Vika said, because the board has not one, but two appeals coming up in the next few weeks, we thought it would be helpful, since I think it's been a long time since you've met, and some of you may not even have been board members, to kind of go over the procedures in the ordinances. And yes, there are two different ordinances, and just kind of make sure that the board is comfortable with the procedures that you should be following. And so I'm going to just do a really quick summary of what should happen at a meeting that you hold, because as Vika said, we're not talking about either of the two pending applications. We're just talking generally about how you would handle them. So as you know, the board hears a few different kinds of appeals, but generally you're either hearing an appeal of the decision of the CEO, or you are hearing an appeal requesting some type of variance. But the procedures for the hearing are pretty much the same. It's just, the legal things that you apply are a little bit different under those. I don't think, unless you want to, I'm not going to go through those various things, undue hardship or the variance criteria tonight. I'm really going to focus more on the meeting itself. So generally with the meetings, you have a little bit more, interestingly, there's a little bit more in your shoreland zoning ordinance about how to conduct the meeting than there is in the regular zoning ordinance. And so I think that what is in the shoreland zoning ordinance is good to follow those procedures, because they are a little bit more detailed. And I don't think there's anything particularly inconsistent in the zoning ordinance that requires you to do it a different way. So of course you get an appeal, and somebody has filed that. And so when we get to the meeting, the first thing that we need to do is, if anybody has any kind of interest in it, and when I say interest, I mean a financial interest, or if you have any sort of relationship with either an applicant or somebody who's opposing something, those are matters that you need to disclose at the beginning of the meeting. So a conflict of interest is defined under the statute as having a 10% ownership interest in a company or something like that. But beyond that, if you have any kind of a financial interest in something, you do need to disclose that, and you should recuse yourself and not participate. So a question that comes up quite often is, well, what if I'm an abutter to something? And the answer to that is, that's not necessarily a financial interest, but it could be viewed as bias on your part. So you should make that disclosure. And so unless something is a very clear conflict of interest, in which case you should just say, I have this conflict and I'm going to recuse myself. In all other cases, if there's any question about something and you're really just making a disclosure for the purpose of putting it on the record, you state what it is you need to state. So for example, I'm an abutter to this property. And you then say, I believe that I can judge this application fairly and impartially, if that's the case. and that I have not prejudged the matter in any way. And after that statement is made, the rest of the board votes on whether you may continue as a member of the board in hearing the appeal. It's very important that these disclosures get made. If they don't get made, then we can, these things are often appealed to court, and we need to be very mindful of the fact that one of the things people like to say is so-and-so was biased. And so if you make the disclosure and the rest of the board says, yes, we believe that you can fairly and impartially hear it, that usually takes that issue off the table for the court. The court will defer to the decision of the board on that issue, generally speaking. I've never seen the court not defer to the board. So that's an important thing to keep in mind. If there aren't any disclosures that need to get made, then the chair is going to, will have already announced what the matter is that's before you, but will then proceed. And what happens first is the applicant, which is whoever has brought this before you. So in the case of an appeal of the code enforcement officer, a code enforcement officer decision, it may be somebody who applied for a building permit and they were denied the building permit. So they're the applicant in that case. In the case where the code enforcement officer issued a building permit and somebody is challenging the issuance of the building permit, they're technically the applicant. And so they get to go first. An important and confusing thing to keep in mind is that your ordinance always says the applicant has the burden of proof. But if in fact what's before you is an appeal of a building permit that was granted, the applicant for the building permit actually continues to have the burden of proof to demonstrate that they met all the standards. So a lot of times you'll have somebody come in and say, I don't think they met the standards. Well, they have to show you that they met the standards. An important thing to keep in mind is that this board is conducting what's referred to as a de novo hearing, which is a lovely Latin term that those of you who speak Latin, probably none of you, means
I do.
There you go. So what does it mean?
Well,
It
means new or
It
again.
means new. Exactly. And that's exactly what you will be doing. So you do not give any deference to when it's an appeal from the code enforcement officer, you give no deference to the code enforcement officer's decision. Code enforcement officer will be there, and at some point you will ask him to present information on the application. But the fact that he granted or denied a permit is meaningless to you. You are making the determination as to whether it should or should not have been granted because you are conducting a de novo review. So what else does a de novo review mean? Well, because you're hearing it anew, it means you are going to hear from everybody. You're going to have a presentation from the applicant for the permit, and they're going to show you all of the information that supports their position, whether they got the permit or didn't get the permit, so they have to show you, well, here's the information on the septic, here's the information on this, if that's relevant to the appeal before you. And then any opponent to that, to the granting of an application, is going to present whatever evidence they have. So for example, they may say they didn't meet the setback requirement, and here I've got a survey to show you. And this is why I'm saying that they didn't meet the setback requirement. And so they'll make their presentation as well. As I started to say at the beginning, usually the person who's bringing the appeal goes first. We have to be a little bit flexible on that to determine, was a permit issued, was a permit not issued? Because frankly, if the permit was issued, it should be the person seeking. If it's a permit, it should be the person seeking the permit who goes first, not the person who's challenging the permit. But especially when they have attorneys, they're going to fuss over that issue. So you can be a little bit flexible on it. It doesn't really matter if you don't do it in the right order. Just keep in mind that the person seeking the permit always has the burden of proof. So whether they go first or second, they have the burden of proof. And when you have somebody who's appealing a permit that was issued, they're going to want to go last, particularly if they're an attorney. And again, I think you can be flexible as to those things. But what's important is to remember who has the burden of proof, what has to be shown for you to grant an appeal when it's particularly an interpretation appeal involving either the grant or denial of a building or similar type of permit issued by the CEO. With a variance, obviously the property owner who's seeking variance has the burden of proof to show that all of the hardship criteria are met in each circumstance. And it has to be, when it's an undue hardship variance or any type of variance, they have to show you that they meet each and every one of the standards. They can't say, well, you know, my lot isn't unique, but I have an undue hardship. No, they have to have an undue hardship. Their lot has to be unique. They have to show you all four of the criteria are met for the undue hardship. And if they fail on any one of them, you have to deny the variance. So you hear from the parties. And then, of course, because you are a public board, you allow members of the public, whether they're parties or not, they can comment on this. They can present evidence. They can say they don't like it. They can say they do like it. They get to do all of that. And of course, they get their chance to speak. After they have spoken, then you will want to have the actual parties, excuse me, the actual parties get a chance to respond to anything new that may have come up while members of the public were speaking, because obviously, particularly the party with the burden of proof needs to be able to address those things. So once you've heard from everybody, and at some point in that process, probably after you hear from the appellant, and if there's an opponent from them, you probably will have your code enforcement officer speak to the application and give you a brief explanation of what he did and why he did it. And of course, excuse me, throughout that process, you have the ability and the right to ask questions of everybody throughout that. Now, whether you want to let them do their presentation first and then ask questions, which I would recommend when the parties are doing things, I think with the code enforcement officer, you should feel free to jump in and ask questions whenever you want to. It is your hearing. You are the board that is responsible for making the decision, and you should be able to get the information that you want as you want it. There are provisions in the state law that say that parties to the hearing have a right to cross-examine the other parties and other witnesses. This isn't often what you will see at board meetings, particularly planning board meetings, is that it's not a cross-examination. They ask a question, but the question is asked through the chair. I will tell you that some attorneys will insist that they have a right to cross-examine the other side. And if they insist upon that, you should let them. But I think you can, when it is a contested appeal, I think that you can try to do the same thing to get them to go to ask questions through the chair, and you will then put the question to the other side so that everybody can get the answers that they feel they need to have to present their case. Obviously at the next meeting, I'll be there with you, and that's we're not going to talk about that application, but we can kind of get you straightened out on some of these procedures if these things come up. So we talked about the presentation. We've talked about the order of things, which is a little bit flexible sometimes. And we've talked about the code enforcement officer's presentation. We've talked about the public. Once all of that is done, the chair can close the public hearing. Actually, my recommendation is that you not close the public hearing, but that you close the public comment period. And the reason for that is that if you close the public hearing, technically you're not supposed to hear any more evidence. And when you start talking about the application, you may find you actually want to, when you start talking, you may want to ask more questions than you did. Or there might be something that one of you remembers one way and the other person remembers slightly differently. And so you want to ask the appropriate parties, whether it's the CEO or the applicant or an opponent, to repeat what they did. So if you haven't closed the public hearing, you don't have to make a motion to reopen the public hearing or do any of that, those procedural things that get to be problematic. The other issue for you to remember is that you do have time periods in your ordinance in which you have to render a final decision. And those time periods run from the close of the public hearing. And so sometimes what's going to happen with some types of applications is that you're going to ask the applicant to bring you more information. Perhaps for a variance, they come in, they've asked you for something, but they haven't given you all of the information that you feel is relevant. And you want to afford them the opportunity to do that. And so if you haven't closed the public hearing, that additional 35-day period doesn't start running until you do close the public hearing. And so in that kind of a situation, what you would do is you would continue the public hearing to your next meeting. And then at your next meeting, you would allow the additional evidence to come in, allow people to comment on the evidence, both any opponent and any members of the public, allow them to comment on it, and then move to your deliberations at that point in time. So it's a very technical issue, but it comes up quite often. And so that's my recommendation to boards, is to give yourself maximum flexibility about things and not be concerned about starting that 35-day time clock. If you're going to do your decision that night, that's fine. But I'm not as worried about closing the public hearing. I know sometimes rules say that you're supposed to do it, but really what you need to do is close the public comment period. So after you've gone through the public comment and you feel you've gotten all the information that you need to have or that's available to give to you, then you proceed to your deliberations, and that is the board's time to talk. You will have people who put their hands up while you're saying things and they want to speak again. You do not have to allow that. You may allow it, but remember that if you allow one person to say something else, you may have to then allow an opponent to say something else, and you might have to allow somebody else to say something else. But there may be times when they put a hand up and say, oh, I want to correct that. That's a misunderstanding. And that it's completely within your discretion as to whether to allow them to speak once you close the public comment portion of the meeting. And you can also instruct people that you're not going to allow them to speak again unless you invite them to do so. It's important for you to, a lot of these things is going to be you and the applicant, and that's going to be it. And so at those meetings, things get a little less formal, but sometimes you have multiple parties, sometimes represented by attorneys. And so it's important to know the things that you should be doing formally so that you can keep control of your meeting, because it is your meeting. It's their application, but it's the board's meeting, and the board's responsible for making sure that things get done in accordance with the law, and that you can get your business done. Now, I should step back on the public comment period. I don't know if you have any board rules. I looked quickly at the website and I didn't see any, but that doesn't mean you don't have them. Normally with public comment, if there's not a lot of people there, you just let people get up and speak as long as they want to. But if it's just members of the public who just want to make comments about things, their neighbors, for example, I'm representing some parties in a matter, and we know that the whole neighborhood wants to talk about it. In fact, it's an island too. The whole island wants to talk about it. In those situations, you can say that other than the parties themselves, that you ask members of the public to limit their comments to 3 to 5 minutes. And you can do that on a meeting by meeting basis. You don't have to have a specific rule about it. At some point, you'll get a sense as to whether it makes sense for you to do that or not. But you can adopt rules that are necessary for you to conduct a specific proceeding. And obviously something where there's island-wide interest in something and a lot of people are attending is one of those things where you can do that. And of course, you should be flexible with the 3 to 5 minutes. If somebody says, I need additional time, then have a motion and extend their time, but not indefinitely. We've all been at meetings where people want to talk for half an hour. Perhaps they only needed to speak for 5 minutes. And you need to be able to conduct your business. And people who are appearing before you have a right to expect that business will get done in a reasonable period of time. So So that's something that can be done if necessary. So you've done all of that. You've had your hearing, and you are doing your deliberations, and you're discussing. As you know, your discussions and your decision-making process is all done in public. If it can be done at the same meeting, that's great. Sometimes you might have to have more than one meeting on something if the presentations are lengthy and there are a lot of people, or there's a lot of evidence, it's a very complicated application, then that's one of those things where you'd continue the public hearing and come back at a subsequent meeting. At that point, once you're done with all of that, then you do your deliberations, and then you have to start thinking about what your decision is going to look like, because as you know, any decision that you make has to be supported by findings of fact and conclusions of law. So to do it in the slightly easier context, which is the variance context, because there's 4 criteria. And so what you would do is go through each of the 4 criteria for undue hardship, and you would talk about them and say, I think this wasn't met because, or I think it was met because, and then the board would try to come to a consensus on that. And at some point you are going to vote each of those 4 criteria on each of them separately. And then at the end of it, based upon that, you're going to have a motion to approve or deny the variance. And obviously, if any of those initial motions was denied, or it was found they didn't meet the standard, but by a majority of the board, then that final motion is going to be to deny it. Even as you know, even if they met the other 3 criteria, you have to deny that application. And the law requires that you adopt the findings of fact and conclusions. So it's important to frame your discussion so that you're thinking about what you're going to adopt as your findings and conclusions. So the basic findings are the property location, the property owner, what relief they're seeking, basic information that you have received that is relevant to the question, the various questions and the criteria. And then you can do all of the findings and conclusions as one group. You don't have to do them individually for each part of the motion. But you do need to include the findings and the conclusions in your motion. Now, for anything where the town attorney is there, there is a possibility that what will happen will be that you would give the town attorney guidance as to what you want included in your decision. The town attorney would ask you some questions to flesh that out. And then you would postpone the matter. You would not take a final vote on it. You would postpone the matter until the next meeting, and the town attorney would provide you with draft written findings and conclusions for you to adopt. So you take that final vote and adopt the findings and conclusions. You can change them if you want to, but so that your final decision includes that. And then you authorize your chair usually to sign the final decision, because it has to get typed up if you make any changes to it. And then that has to be, the written decision for the ZBA has to be issued within 7 days under the statute. And so it's really important that we have the findings and conclusions ready to go with that decision. Otherwise, we're not in full compliance with the statute. And that's a departure from the planning board. There's no planning board statute per se. There are some statutes that talk about them, like the subdivision statute, but they don't have the same absolute requirement that a decision be issued within 7 days. There may be something in your ordinance, but it's also not 7 days. So it's important that you not put yourself in a position where you've made a decision, but you haven't adopted findings and conclusions, and you're coming back a month later. That's not in compliance with the statute. So that is kind of a very quick overview of how a meeting goes. And I think really we wanted you to have the opportunity to ask me questions about things. And before we start, can I just ask, have you all been on the board for a while? You have?
Yes.
Okay, so some of this is going over stuff you already know. We're kind of refreshing your recollection, because I think has it been a while since you've had an application?
Yes. March, I think.
Yeah. So So we wanted to give you the opportunity to just kind of go over these things and ask me any questions that you have about things.
Okay, so I have a question right now. So we're in the meeting. We're not ready to say we need some additional information. So we have the public hearing going on. And at that point, I say I want to adjourn the meeting, but I don't want to start the clock running on anything. Do I just say I want to adjourn this meeting, but does that mean that, like, in fiction, the hearing is still going on even though we've adjourned the meeting and then we're asking for somebody to come up with additional testimony?
Yeah, I'd get away from the term adjourn. I mean, it is a technical term. I would recommend that if something comes up and you feel you need additional information on it and you're being told by somebody there, I can't provide that to you. I need to get that information. Then I would suggest that what you do is you have a motion to continue the public hearing to the next meeting. Postpone is another thing that you can do, to postpone consideration of this and to continue the public hearing at the next meeting until you are able to get the information that you need. And that way you haven't started the time clock. But
And what are the constraints? I'm sorry.
No, you go ahead.
What are the constraints? Should you make a motion to continue? What are the time constraints then until the next meeting? What are the time constraints? The clock doesn't start till you make your final decisions, but isn't there?
Well, until you close your public hearing. Once you close your public hearing, you've got time periods that start running. So you leave
we
that
could
open.
do it, postpone it for a year. I mean, is the timeliness, what's the timeliness of this?
Yeah, that's a great question. It comes up quite often because sometimes the information that you're asking for might be technical information, and to get on your next agenda, they would need to have it in a few weeks. And they tell you, I can't get my engineer to do it within that time period. So there are a few things you can do in that instance. One is you can continue it until your next regular agenda. But do you have regular agendas?
No.
Or you just continue till, okay. So
we only meet when we have a hearing.
when you have something. So at that point, you can do a couple of things. You can say, we're going to continue it until the information is received. If you do that, new notice of the meeting has to be given. Or you can continue it to a date certain. And if you announce the date certain at the meeting, you don't have to give a new notice. So something that you can do is pick a date certain, maybe it's 6 weeks instead of a month, and say, this is when we're going to have it. And then if the applicant comes back and says, I still wasn't able to get it, then you would have a very short meeting and continue it again. So you can do it either way. It's just that you need to be mindful that if you don't set a new date, notice has to be given, and you'll announce that at the meeting, that when we receive the information, we'll schedule a new meeting and everybody will get notice of that.
Okay, I've been on the board for quite a long time, and I have never seen a copy of our board's bylaws and do not even know whether we have any.
You may not. A lot of boards don't have them.
Ted, do you know?
No, I've never seen them either.
Yeah, I don't think we have any. So we may need to come up with some, because I mean, we have 3 members here. We only have 4 members right now on the board. And I think our ordinance calls for at least 5, but I think the Maine state one says 4 to 7 or something. So, what was my point? I don't know. We don't have many people here. So
you can have 5 to 7 members, and you can have alternates, but you are not the only town that's going to say to me, we can't even get the 5 members, so we can't get alternates. It is a problem, and not just on not just in smaller communities, larger communities are struggling, some of them anyway, with their board membership, and particularly the ZBA because the BAA, because you're the board that usually has to say no to things. So, planning board's a little bit more popular, but and it's especially hard for Islanders to give the time commitment that you need to for this kind of thing, especially if you work on the mainland. So
It's also especially likely that someone may have a conflict of interest. I noticed that in the stuff that Vika sent us today, there's something called the rule of necessity, so that even if a party objects to us because we worked for the person bringing this complaint, if there were only 3 of us on the board, we couldn't really be sidelined and make a decision.
yeah, hopefully we never have to deal with the
Okay.
necessity. We hope that's true. But again, that's one of those things where a disclosure
Right.
probably is helpful. And the fact that somebody did work for someone, that's not a conflict of interest. That's viewed as bias. And they can challenge you participating based on bias. But again, as long as the rest of the boards heard the disclosure and said, yes, you can, you're not going to say yes if somebody wants to sit on an application and they've already prejudged it. You're not going to do that. And frankly, I trust all of you to not ask to participate in something where you've already prejudged it.
Right.
Because of your nature of your knowledge of the property or whatever. So I'm not concerned about that. But it is something that comes up. So yeah, that's why you have to do the disclosure and the vote.
Okay. Also, since we have no bylaws, we also have no listing that there's a requirement for a vice chair. It just says chair and secretary in the ordinance, I think.
That's what the statute says too. It says chair and secretary. And so what some boards do is they have I know why the statute calls for a secretary. It's really outdated. You don't need a secretary. You either record a meeting, or in larger municipalities, they have a recording secretary who's an employee. But the statute still calls for a secretary so that somebody is keeping minutes and keeping track of the meeting. So a suggestion would be to meet the statutory requirement that you have a vice chair / secretary.
Okay.
Now, the secretary is not expected to keep minutes. I just don't know how anybody could keep the minutes and participate in the meeting. I don't know how that ever worked. That's what the statute says.
That's a relief.
Yes.
Myself kind of going like, this is a meeting.
Yeah.
I think, and actually that's a good thing to bring up as well, because in the context of doing the decision, when the board's on its own and doesn't have an attorney there, and you still have to do the written decision, we can give you some forms for variance stuff, but it's hard for us to give you a form for an interpretation appeal because each one's different. But somebody is going to have to write that up at some point.
Right.
And so that's another reason why don't do your final vote, go around the table, have your discussion, or around the Zoom, have your discussion as to what you think should be in a decision, and then postpone it. Bring it back to the next meeting, do the final vote, and have somebody have drafted something out for your adoption. And on the decisions, you probably know this, but I'm required to say it because every once in a while I'll have a board say they can do this and you can't. You cannot rely on your minutes as your written decision. The only way that you can do that is if you take a vote on your minutes and you sign them. And obviously doing that within the 7-day period is not going to happen. So you do need to have something that's a letter, or even just a document that can be attached to a letter that's got your findings and conclusions in it.
In previous hearings that we've had, Peter always asked us to approve the previous hearings minutes, which.
Yep. Yeah, that's a standard practice.
But we wouldn't have, you're just saying we wouldn't have minutes because the secretary would not have created minutes, but
You may have some basic
Opinions.
minutes, and I don't know if in some towns the code enforcement officer will do very basic minutes for you. And the minutes,
okay,
the only thing that's required under the law is a record of the motions and votes. That's all that's required. Now, that's from the record keeping standpoint. Obviously, that's not from the decision making standpoint. So somebody has to generate that, but it doesn't have to be, verbatim minutes or even a summary of the discussion, because that would just take somebody out of the meeting entirely and participating, because they'd be too busy listening to everybody else.
Yeah, in previous meetings, years ago, the CEO oftentimes would write out, almost kind of fill in the lines for me to and then we, of course, the specifics we'd add. He would not know what those would be, but
Right.
he had put them in order, and it's just so to make sure that the document that I generally created was met what you have just spelled out.
Yeah, and for a variance, the code enforcement officer can help you write out your decision. For an interpretation appeal, it's the code enforcement officer's decision that's being appealed, so it's not
Right.
very appropriate for him to be helping you with those.
okay.
And those actually can sometimes be much shorter decisions, because you don't have the 4 different criteria that you have to address. You're just talking about, these are the facts, and this is what we think. We think the code enforcement officer's decision was correct because, or we think he was wrong because, and based upon whatever documents you rely upon or whatever information you've received. Do you want to talk about whether you have to accept expert testimony and have to reject non-expert testimony if there is expert testimony?
Geez, I think the last time we ever had stuff like that was when the Cox Chapmans wanted that pier built. They had expert opinions, but they were written, and they were just, I think they were given as part of the appeal or complaint. Do you guys remember that? I have a huge binder that they prepared for us. So I'm just saying, I don't think we have, I personally don't have that much experience with expert opinion. It's mostly just neighbors.
Well, and when I say expert, I mean somebody has an engineer, and so
Right.
neighbors will come in and say, well, I don't agree with that. And you get to decide what weight you're going to give to evidence. The fact that somebody has had an engineer say something, if you get credible evidence from neighbors, and honestly, this comes up most often in the context of traffic, so that's not really an issue for you guys, but for example, well, it could be, I guess. But there's a case from the town of Gray. It's an old case where the applicant came in and made a presentation on the traffic, and it probably wasn't as sophisticated as they would be today. And the planning board member said, well, we're sitting right here and we see the intersection that you're talking about. And we have to say, we don't agree with any of the stuff that you've provided to us. It's not what we can see with our own eyes. And so we think you haven't met the appropriate traffic standard. And actually the law court said that was fine, that board members can't go out and do their own research because you can't become a witness at something. But that doesn't mean if there's something of general knowledge within the municipality, as was the case in that Gray case, there's an intersection, everybody knows it, everybody drives through it, that you can't rely on your own knowledge of a situation, as long as, it's reasonable knowledge of something. Now, again, you're not going to say, well, my opinion is that you're wrong. That's not what I'm saying. What I'm saying is, well, you're saying that this works at this level, but this is what we actually perceive when we look at it. But again, when you are doing these decisions, as you know, if you have a site walk, and you don't have to have site walks, you all have to attend the site walk. And you all have to, if somebody misses the site walk, someone should summarize what happened at a site walk at the next meeting so that that person has the same information. But one of the most important things is to keep in mind that, as I said before, you can't become a witness. So you can't go out on your own and look at a site and say, so I was out there and I've got to tell you, this is what I saw as to the drainage. That's bad. And that's not something you're allowed to do. That's not something any board member is allowed to do. And it takes you out of being the judge and puts you into being a witness. And obviously you can't do both. The judge can't testify at the trial, and the witness can't be the judge. So you want to avoid those types of things. I don't know if you do site walks as a general matter of course. You're not required to. That's usually more of a planning board function than a board of adjustment and appeals function. But it is something you can do if you want to, but you're not required to.
Are we planning to have one for this hearing, before this hearing? Are we planning to have?
I don't know. It just, we're not supposed to talk about this.
I would just say, generally speaking, I don't know that you're required to.
No.
And I'm not speaking about a specific application, but you're
Right.
not generally required to. Now, if you get at the meeting and you say you think it would be valuable to do it, then that's one of those things that's additional information. You postpone the hearing and you schedule a site walk that members of the public also may attend. If you have a site walk, you need to tell everybody who's in attendance, please do not talk to us about the merits of the appeal. We are here just to gather factual information to address issues that the board may have. And if you have an application where somebody has an engineer, it is okay to ask the engineer factual questions while you're right there. But then when you come back to the next public meeting, it is a good idea to summarize what you saw on the site walk and any information that you received so that everybody knows what you saw, what you did, and what you're thinking about after that. Well, you're not going to talk about what you're thinking about, but they're going to know what it was that you saw and what information you received of that. But don't allow it to become an opportunity for lobbying on either side.
So if we got an appeal and we all looked at it and said, we can't understand the complexities of this appeal unless we actually walk the property. And we could do that well before the hearing. We would have to notify the public, but we could do that before the hearing. Is that correct then?
That's right. You're absolutely right on all of those things. You have to notify the public. The public has to be allowed to attend. If somebody who is a property owner says, I don't want the public on my property, my recommendation is that you not go on the property, because that way there can't be any issue of, well, they had an ex parte meeting with the applicant and we weren't allowed to participate. Because as you know, you cannot have ex parte meetings with anybody, with any party to anything. And so, but yes, you absolutely can schedule them. You do have to give public notice of it, and they have to allow members of the public to come too. And another thing for either the secretary or somebody else, I will tell you that I do have, well, it's a planning board at one client where they actually do some very brief notes about what happened at the site visit. So we arrived at this time, we walked the property with the engineer, whatever, just as an additional record keeping. That's not required. And I always hate to ask volunteers to do more than you're already doing, but you know, it's not a bad practice to have if you do decide to do a site walk.
And then would those minutes be included? Must they be included in your conclusions?
No, they don't have to be included in your conclusions. They just become part of the overall record.
Okay.
I mean, they would be included in your conclusions if when you came to the meeting, you said, based upon what I saw,
right.
you know, this is where I am, then yes, it would be. But the minutes themselves, if you did them and you don't have to do them, they just become part of the overall record.
So in one of the packets that you sent out, the general guidance to planning boards, you know, it had the, you know, their kind of a laundry list of how to run the meeting, which I think Peter would go by. The first thing
Yeah,
on their list was we need to establish that we have a quorum. And the second, it's a, you know, a numbered list. The second thing was the timeliness of the appeal,
Mhm.
and whether or not notices were given, you know, to make sure that the meeting has actually been properly noticed. And then like the fourth item, well, it was that the chair should summarize the appeal.
yeah.
Yeah, I did.
I just wrote all those down
Yeah,
too, Charles.
Right.
for the planning board, that's a good practice. For
And
you,
then to actually, to document that we had jurisdiction,
Right.
and then, you know, actually enter into the record what type of appeal it was going to be, it is de novo. But
mhm.
it was only then that they got to the conflict of bias.
Right, whereas I think Peter listed it first on his things, or conflict of
If we don't
interest.
have a quorum, we can't start, if we don't have, well, I guess,
Well, technically speaking, you still have the quorum, but the reality is if you're not going to have enough people to vote, because you need to have a majority of the board voting, so the vote that's required is the same as your quorum. And where you have 4 members, that gets problematic pretty fast. So I would say it's fine to say this is the matter, you know, this is where the property is, blah, 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 before you talk about the conflict issues. But I don't think that somebody who has a conflict should be discussing any other matters. You know, is it timely? Is it any of those things? It shouldn't be discussing that. If you can't participate, you can't participate at all, not just as to the substance, but also as to those procedural issues.
So that should really be the first.
Should be
issue.
first. Yep. Right.
Yeah.
Yeah. After you announce it, it should be, does anybody have any disclosures, or does anybody have any interest or any conflict? And that would be the first thing you do. Then you can move to the subsequent things. Is it timely? Do we have jurisdiction? I think is a good. I always assume jurisdiction if it's before you, because usually if it's not, we try to cut people off at the pass and tell them that you can't hear it, but they can insist that they come before you. And if so, you may, it doesn't hurt, and it probably is a good practice to be going through the jurisdiction. You know, for a variance, it's easy. Yes, we have authority under this section of the ordinance and also under state law for the interpretation appeals. It's an appeal of a decision by the code enforcement officer, and we have jurisdiction under this provision of this ordinance, whether it's shoreland or zoning. So yeah, it's a good practice to do that.
So if someone has a conflict, or 2 members of the board have a conflict, it's disclosed, the person says, yes, I can judge this fairly, or no, I can't, so I must recuse myself. And then the board must vote on whether that person who said, I can do this fairly, whether
Yes.
they agree. And is
Yes.
that correct?
That person
Okay.
is not allowed to make that decision for him or herself. That has to be made
Right.
by
So
the
you-
board. And the person has to comply with what the board says, even if the board said, even if the member said, oh yeah, I can hear it fairly and impartially. If the board says, we don't agree that you can hear this, then that person can't participate.
And if you're down to 2 board members, then you may well have to let that person participate due to this
Well,
of necessity.
I, well, there is the rule of necessity, but I'd be careful about that, because if you have somebody participate who everybody has said, we don't think you can fairly and impartially hear the matter, how do you think that's going to turn out if it goes the way that person
Right.
is leaning? And, you know, even if the other board members get there independently, the claim is going to be that person unfairly influenced the rest of the board. So I get what you're saying. It's a real problem and not just for Shabby, but hopefully we just don't come to that situation.
Well, in that list that Charles was referring to, they also list that at some point you have to establish whether the person filing the complaint has standing to do so, I think, right, Charles?
Yes, yep. And so if it's the person who's seeking an approval of something, they're going to show you they're the property owner. They're going to have already shown that because I think it's required as part of your application process. So you can just say they provided us with a deed and so they have the ability to pursue this. If it's in a butter, then you ask them question. You know, don't assume it's in the butter. If somebody else brought the appeal, you say, where do you live and what is your standing to bring this? And you know, if it's just people there on their own, you might have to walk them through that a little bit, ask them where they live, how close they are in proximity to this, because it is true that somebody has to have standing to bring an appeal before the board. And usually that means it doesn't have to be a direct abutter, but you have to be within some proximity of it. There's case law where people, and again, on an island said, well, I drive by it every day. And the court said, yeah, but you live on the other side of the island. It was a pretty sizable island. And so that's not standing. So that is an inquiry you have to make. You are a large enough island where people don't automatically have standing to challenge everything that people do.
But in the findings of fact, does that need to be, you know, spelled out in the findings of fact?
My answer to that is not going to be the best answer you're going to hear, which is it depends on how contested the hearing is. It depends on, you know, if it's contested, yes, put it in there. If it's something that's relatively easy, and they've said they're in a butter, you can just put in the decision that the appeal is brought by an abutter or the appeal is brought by somebody who lives in close proximity to the property. And that answers the question without going through the very legalistic analysis of, yes, that person has standing, that person has this, that person has that. Very handsome cat.
Oh, is there, I just have this demented, incontinent dog behind me that wants to go out. He will just pee randomly on the floor. So just waiting for that to happen. It's like having a toddler in the house.
So I don't have the checklist that you have, but it sounds like it's really good. And so I think that's a good idea to have that at upcoming meetings and to go through those steps first thing. It's funny because usually when I'm involved, it's something that's very contested and we've already looked at all of these things. I don't really focus on that, but it's a good practice. So I'm glad that you have that checklist because it sounds like it's well organized for you.
And we always make sure they paid their fees.
Yeah, see, I'm not as worried about that as you are, but yes, it's not a complete application without a fee.
Yeah. Well,
Natalie, what I sent them was, I went to the Maine Municipal website and went to, you know, Board of Appeals, and then kind of the procedure that you're required to go through, just kind of a general guideline from that. So that's the information that they're referencing.
Okay, great.
is that available publicly? I'm sorry. Is that available
You can make it
publicly?
available
'Cause
publicly.
they had all these appendixes that you could look at and use as templates, which might be interesting. And
I'll take a look tomorrow to see if we have the appeals binder. If it is, I'll let you know. You can come take a look at it.
oh yeah, and copy some pages.
Otherwise, you get, as a member, all of those binders are available online. And so,
Oh, okay. I'll just
you know, you can
check online. I've never gone to the meetings because they're always at weird times in odd places, but
yeah. So if you do have the ability to go online, all of their either I have a little trouble finding them, but they are all there. So, and the board ones are very well done. Obviously, MMA has a ton of experience, and they have some good forms for people to utilize. So we
I have one, oh, I guess you can continue if you have a case that has several issues or a complaint that has several issues. Is it, if you can decide on one immediately, can you then refer the other two for a continuance, or?
You have to continue the whole matter. You can have a
Okay.
discussion about it, and you may come to, you may have a around the table discussion and feel that you're comfortable on that issue, but you shouldn't take a vote on one issue without being ready to vote on the whole thing,
Okay.
because that raises questions about, well, gee, was that appealable? It's not. You have to have a final decision, but the last thing you want to do is create any kind of ambiguity so that somebody who's appearing before you isn't clear as to what they have to do, and then we get an appeal that's not, it shouldn't have been made at that point in time, and we have to start dealing with that sooner than we should. So you certainly can have your discussion about it, and then you get to the next matter and say, well, I want more information on that. And of course, then when you determine you want more information, you're going to go through the other things and say, I'm going to need more information on this, or I'm not going to need more information on this, so that they know exactly what to bring back to you.
Okay.
So in that guide, they mentioned a case called Hughes versus Black.
Hughes versus Black. What did they say about Hughes versus
It
Black?
has to do with, it just has to do with it has to do with the conflict. What constitutes a conflict of interest for somebody, a situation where somebody had worked for somebody or was an employer of an appellant, or where the person was, a family member working for the appellant. It was something,
Well, let me see if I can find it.
something like that, because some of this is kind of a little nuanced. What I find with dealing with conflict of interest, there's some people who look at it and will basically say that, well, none of us can vote on anything because we all pay taxes, or, that. So, and especially,
Natalie, I just forwarded you the email that I sent to them this
Oh,
morning,
okay,
and
great.
it's 2
Yeah.
chapters that are attached. So, Charles, if you want to be a little bit more specific about which chapter and where you're looking for, it might be helpful.
no, this isn't, well, okay.
Hughes versus Black, which I was going to look up. Is it HUGHES or HEWES?
I think it's HUGHS, first Black. Well, do you know Aldom versus Roseland?
Nope.
Well, that's the one that says you should, if you can, you should do everything to even avoid an appearance of conflict.
Well, the statute says you're supposed to avoid, oh gosh, that's why I don't know that case is from 1960. Let's see what that has to say.
Yeah, it's 1960.
Well, Hughes versus Black is not, it's not really a land use case.
But this was
It
just.
talks about a judge. It talks about judges, and there's some similarities. Judge won't preside in a case in which the judge is not wholly free, disinterested, impartial, and independent. I think that's probably what they're getting at. And it talks about the law used to be the common law, which of course is case law. The only ground for recusal of a judge was pecuniary interest or relationship, which interestingly, that is pecuniary interest is what a conflict of interest is defined in under the municipal statute. It's a pecuniary interest, and it's not just any pecuniary interest, it's 10% or more, but anything beyond that, anything less than that, then you have to disclose it, because there's the possibility that it will be viewed as bias in your opinion. So that's what Hughes versus Black is.
Well, let's come at it a different way. I'll give you a hypothetical. Say a member of a Board of Adjustment and Appeals is a roofing contractor,
Mhm.
and they were hired by the appellant to replace the garage roof. And it was they didn't own 10% of the company. They didn't own anything. There was a transaction. They performed some work for them, and they were paid for their work.
And the work is done, and it's not the subject of the application.
It's not the subject of the application.
So does that have to be disclosed? And the answer is, it doesn't have to be, it doesn't hurt to be.
Yeah,
Because
I
remember,
think I would disclose it. Just say, I worked for these guys
Yeah,
5 years
the
ago.
question
I
was
replaced
whether
the
or not
roof.
to disclose it. My question had to do with, is it disqualifying?
no, it's not disqualifying, it's disclosable. It should be disclosed, it's not disqualifying. And honestly, if the owner of the roofing company came in and said, I built a roof for them 10 years ago, and they get 100% of it, that's not disqualifying either. It's having a financial interest in the matter that's before you. The conflict statute is a little bit, it's a little bit of a mixed bag because it applies across the board to everybody. So it's not just the board members, it's also the select board. And for the select board, you can't participate in the issuance of a contract for obvious reasons where you have a financial interest in it as defined in the statute, which is the 10% ownership interest. But for the rest of you, well, gee, are you really participating in it? You have to make the disclosure. And if you have a 10% ownership interest, you should be recused. It doesn't come up that often, but sometimes for contractors it does. So if somebody says, I'm going to be the contractor, if this appeal is granted, that's probably something where you should be considering recusing yourself, because you have some level of financial interest in that application proceeding. And, are you going to vote against something if the person has said they'll hire you if they get it? Please, I hope none of you are in that position where people hire you to do work in case they get an appeal granted, but it does happen. And in those cases, we tell board members who are in that situation that they really should recuse themselves.
I have
Well,
just
see what people-
one more general question on ordinances and timeliness. If no timeline is stated in an ordinance, is
It could go on for
time
years.
of the essence, or if someone claims that someone else is dragging their feet and that's why they're bringing this appeal, and there's nothing in the ordinance that says you have to do this in 10 days. Where do you weigh in on that? Is that,
Do you mean that there's nothing in the ordinance that says the board has to do within 10
no, it
days?
says like anyone. Yeah, if the planning board can vote on something or
Mhm.
has jurisdiction over this, and then someone brings a complaint saying the planning board took 4 years to do that, and by that time I couldn't afford to build my house. If there's nothing specifically in the ordinance that it just says the planning board must vote on this or has jurisdiction over it, but is timeliness implied? Is there any penalty for not doing things in a timely manner? That's if it's not expressly stated in an ordinance.
There's not a penalty for it, but if somebody could appeal. If you fail to act on something, they can bring a Rule 80B appeal, both from an action and from a failure to act. So if you take a long period of time and you don't reach a decision on something and they say, you know, there's absolutely no reason for this, they won't schedule me, they won't do this, they won't do that, and the town doesn't have a good explanation for it, that's something that can be appealed. And
Okay.
usually they'll let you know that they're going to appeal it if you don't do something, and then you go ahead and you try to get stuff scheduled. But if taking years to make a decision is something that's a problem, there are a lot of towns in Maine and cities that have a big problem.
Yeah.
And obviously, that's more of a planning board issue than a board of appeal adjustment and appeals. I should know this more than for you, because the things that are brought before you are much more discrete issues than the planning board things. You know, the planning board's got a subdivision; it can take a year or more to approve it, because it's pretty complicated.
Okay.
Right, I think John Comlosi took it took over a year to get all of his stuff in line.
Yep.
Because you had to go back and get engineered studies and, you know, and stuff. So, but that was a planning board thing, not ours.
Right. Right. And some of the pier construction, depending upon, you know, the nature of the pier and where it is, that can take a long time, because you also have to get some state approvals, and you might need those depending upon where you are in the application process. So these things can take a long time. But again, with the Board of Adjustment and Appeals, it shouldn't take more than a couple of meetings, or possibly 3.
Okay.
On how complicated something is.
Okay. I don't think I have any more questions, but I thank you. I feel much more enlightened.
Yeah, Vika, thanks for sending those things out. They're quite helpful. I haven't looked at them in a while because I teach this, but they are, you know, their MMA stuff is always very well organized and helpful.
And it's pretty well written, so it's easy to digest.
Right. Yeah, it may be written by lawyers, but it's written for non-lawyers, which I think is quite helpful.
And I did check, we do have manuals that we've bought from MMA on just about everything else,
okay.
but I don't see one on that one. So it looks like it might be something we're going to be ordering.
Well, if we can go on their website and look up this thing and just download the stuff, that would be helpful for me, because I like to print it all out and put it in a little binder.
Yeah, absolutely. So does anybody have any more questions for Natalie before this gets switched into kind of a regular meeting where you guys can appoint a chair?
I just have are you usually available? I don't remember you being available by phone when we've had other hearings, but
It's been a while since I've done, I have been on the island for meetings, but it's been several years since it was pre-pandemic, so it's been several years.
okay.
I will be at your next meeting.
Oh, okay. Not that we know what that next meeting is, because we're not supposed to talk about it, but
I probably won't be at the meeting after, well, we'll see. And we're not supposed
Okay.
to talk about it, and I've already violated the rule.
well,
But I will be there.
whatever. There will be another meeting that you probably won't be at.
Yes, well, we'll see, but I don't think so. So for next time, we can put all this stuff into practice. So.
And then when you are at that meeting, we can ask specific regulatory or questions pertaining specifically to the case, which we are not discussing now,
Yes, at any
but
point.
would be
in time,
discussing in a hearing.
yes, at any point in
Okay.
time, you can do that. Now, one thing that I will say, and this is across the board, if you have an attorney there and you ask your attorney questions, the other attorneys will want to debate those points. You may, what I would suggest that you do is say, we'll give you an opportunity to respond after everything is done, and then you can respond to everything. And again, it's not necessarily that it's required, but we don't want challenges to due process that, well, I was denied due process because, they got this opinion. I had a different opinion. Well, of course you have a different opinion, but still, it's just easier to allow an opportunity for that. But remember, each attorney is going to want the same opportunity, and some members of the public may as well. So you have to kind of draw that line, but it's a good idea to afford whoever is getting an opinion that is contrary to what they've said the opportunity to argue a little bit about it. Not too much, but a little bit. So it's on the record. That's what they would tell you, and that's right. They have to preserve their arguments. They have to say, I raised this argument before the Board of Appeals in order to be able to bring it to the court.
Of course. Okay. Well, I'm happy. Thank you.
Well, thanks to the three of you for participating, and thanks for being board members. Vika, I assume you don't need me to stay for the election.
That's correct. Thank you very much for your time.
Thank you. Nice to see
Have
you.
a good night.
I never see you, Vika. Bye, everybody. See you next week.
Bye. Thank you.
Thank you.
Just say cat power. He just ate cat power.
All right, so seeing that there's only three of you,
We don't have a quorum.
you
Well,
have
there's
a
only four
quorum.
members,
There's
so we
three
do.
of you. So if you wanna, guys, take the lead and kind of start the meeting, decide if you're able to, because that was a workshop. So now you're having a regular meeting. If you feel like you're able to do that, and elect a chair, then you can kind of run with it and then document it, and then you can elect a chair. If you feel like you need the other member here present for it, then that's something that we can advertise and you could do before the hearing next week.
Whereas where we don't have a quorum,
Well, we do. We only
You
have
you
4
need
members.
three
and there are
people for
three
a
of the 4
quorum.
here.
You need
So we
three
do.
people.
yeah,
Three's a quorum. Oh, great. Okay.
Yeah.
So I guess the question is, are you feel comfortable running the meeting, regular meeting now to appoint a chair, or do you want Cheryl to be present for that?
well, it'd be nice for Cheryl to be here, but if we have a quorum, and it depends on the number of nominations for the various positions, whether or not we can carry it out. If there's just one nomination, and I'm prepared to make a nomination, then I suppose it depends on the number of nominations and the votes involved in this and how we vote.
We just, yeah. I say we just go ahead because we don't even know if Cheryl is going to be at that meeting.
True. Unless we do
Didn't
absent.
sound like she was really aware of this meeting. Are you sure she's getting the emails?
Yes, because she's responded to my emails.
Oh, okay.
So if you guys want to go ahead and run it, I'll sit back. So you just, start the meeting at whatever time and then do your thing.
Okay. Okay, let's go.
Okay.
Well, I guess I'm the only officer
You're the only officer.
present.
You're the highest ranking
I'm the
official.
highest.
Yeah, so we defer to you, Tad.
Huh?
We're deferring to you.
All right, well, let me call the meeting to order.
I hope you're writing the minutes now.
I am at the same time, it's my head going like this.
No,
So-
to make things easier, why don't you let me take the minutes and do the time and
Oh,
record the
okay.
motions, and I'll share them with you afterwards.
He's going to be the secretary.
Oh, it shouldn't be second. Thank you, Vicka. I guess we have just one order of business to accomplish this evening, and that is the selection of what I statutorily is the chair of the board and the secretary of the board. We can combine the vice chair and secretary positions if we choose, and maybe we should decide on that first. Is there any discussion on whether or not the board feels that there should be this combined position of vice chair and secretary, or should we just go with the statutory chair and secretary positions? Any discussion on that? Any motions?
I have no opinion either way.
So what have we been doing up until now?
It's been chair and secretary.
And how has that worked?
It's worked
As a
fine.
secretary?
It's worked fine.
I make a motion that we continue having a chair and a secretary.
Second,
Okay.
all in favor? Good.
Unanimous. Okay. The decision then is to go ahead and make nominations for the two positions. We'll start with chair. I would like to make one nomination for that position. And that position, for the position of chair, and that's Sam McLean.
I second.
All in favor? I mean, I would do it. And
And
I'm not, oh, you have to nominate the
do we have any
secretary.
other nominations for the position of chair? Not hearing any, I would make a motion to close the nominations for the chair of the Board of Appeals and Adjustments for the town of Big Island, Maine.
Second. Oh,
All in favor? Now, for the position of secretary, are there any nominations for that?
I nominate Tad, as he's a wonderful secretary.
Is there a second to that nomination?
I second.
Thank you, John. I'm willing to do it. So therefore, I guess we vote for ourselves on this one to get a
Yes,
majority.
you do. It's okay, Tad.
Oh, it is okay. Okay, fine. So all in favor of Tad Runge for Secretary of the Board of Appeals, raise your hands. Fine.
For life,
It's unanimous.
right?
Not to vote for yourself.
The cat was about to vote for me here.
Yeah, the cat's in favor of you, the dog.
Yep. Hey, is there any other business that we'd like to accomplish at this meeting tonight? Not hearing any. Make a motion to adjourn the meeting.
I just have one, maybe at a future point, maybe we should make some bylaws, just because the makeup of the board will change. And as we get away from the Peter Rice definitive lawyer running the show, it might be easier if we had a few bylaws, just a suggestion. Okay, we can now adjourn. I will zip it.
Becca, would you please include that in the minutes for future reference, please?
I mean, she's the one who sent us these helpful chapters, which says we need bylaws. So we should probably have some. Okay,
Motion's made to adjourn the meeting. Is there a second motion to that motion?
second,
All in favor?
aye.
Thank you, people, for being here tonight. Becca, thank you for arranging this. And
Yes.
it was very helpful, I think, for all of us.
Yeah, absolutely. So we'll see everyone next Thursday at the hall.
Thursday, is that right, Becca? Next Thursday? Yeah.
Yep, Thursday at the hall, 5 PM will be the first hearing, and then Sam and I will need to get together, and the second hearing has to be done. She would set the date for the second one.
So it's at the hall and it's 5 o'clock.
Yes.
Yes, because the rec center has stuff going on now, a lot of the time. Sorry, there's a bug. Okay, and you won't be around till after the 14th?
Yeah,
There's
that-
fruit
that
flies,
is
I'm
a
sorry.
problem for me, yeah. So I don't know yet. I could be there. We may want to just pick a time that week if we need to, and if we can't get an extension on it, do we need to discuss that possible extension of that second one at the meeting next week?
Okay,
If you wish, if you want me to be there.
no, makes sense.
So
Just need to
I
know.
might be there. I just don't know at this time. I committed myself for that whole week. And it's still loosey-goosey, unfortunately.
Yeah, I'll connect with Sam and then give her the protocol about what she needs to do going forward to plan the meeting. And then she'll touch base with the rest of you.
Super.
Okay?
Thank you.
Okey-doke.
All right. Thank you,
Bye,
guys.
guys.
Have a great night.
Thank you.
See you soon.
Okay.